That's good. That's good. All right. So it looks like we are going live. My name is Amy Gromowski. I am an attorney in Kansas City, Missouri. Amy, the attorney. I'm licensed both in Kansas and Missouri. Since about mid-March, I have been having people on my Facebook show. This will also end up on my YouTube channel. And I wanted to invite lawyers to speak about how the law is intersecting with the pandemic and COVID-19. We've had criminal defense attorneys on, we've had consumer fraud attorneys on, we've had small business attorneys on. So please go check that out, both on this page and in the page, my YouTube page. I invited Kristi Kingston on today. She is an employment lawyer. She has been an employment lawyer, I believe, her whole legal career, and she has always represented people. And so I'm very excited to have her on. She is smart, she is hardworking, she is diligent, and when she represents somebody, you know that they are going to be represented in all the best ways possible in terms of protecting that person's rights. So what we're going to first of all be talking today is we're going to be talking in general about laws in Missouri and Kansas as it relates to working people. And then we're going to talk about the CARES Act, which is the federal legislation that was passed in March relating to COVID-19 and some protections for workers and their families. And then we are going to talk about the situation now as states, cities, counties are going to be reopening, and what happens if you're in a situation where maybe you don't feel safe going back to work. Maybe you still have a child at home that is sick. All these different situations now where we did have some opportunities to stay home without retribution, but going forward as places are opening back up, our workers still going to have those rights. So Kristi, thank you so much for joining me today.
Great. Good morning. Thank you very much for having me, Amy, and for that very nice introduction. That was sweet. Thank you.
Well deserved. Okay, so let's just talk about in Missouri and Kansas, just general employment. If you're employed by somebody, what rights do you have if you're fired?
Sure. Both Missouri and Kansas are employment at will states, which means your employer can fire you for any reason they want. Now, there are some exceptions to that, and that's where my office comes into play. I represent employees who have been discriminated for illegal reasons. And those illegal reasons include being fired because of your race, your sex, your national origin, your religion, because you have a disability, because of your age. Specifically, people may not be aware, but if you're over 40 years of age, you're protected under both Missouri and Kansas and federal age discrimination laws. I also represent employees that have been fired from work for unlawful reasons. That may include that they reported that they felt like they were being discriminated against and then were retaliated and fired. I represent employees who have made workers' compensation claims and feel like that they were then fired for filing that worker compensation claim. I represent employees who are whistleblowers. Whistleblowers are people that either refuse to engage in illegal activity that their employer wants them to engage in, or people that report that their company or their employer is engaging in illegal activity and refuse to do that. So there are protections that the law provides for employees that are exceptions to the employment at will laws that are in Missouri and Kansas. And that's where I come in. I advise, give recommendations, and ultimately hopefully represent employees who have been discriminated against, retaliated against, or wrongfully terminated at work.
Okay, with those cases, and even further with the cases that we're going to talk about in regards to the CARES Act, when should people call you? Do they call you the day they got fired? Do they call you when they are at work and feeling like, oh, things are going poorly? I say it's a whistleblower can't claim. I told them, about this unsafe situation, and now they put me on the doghouse hours and, cut my pay. When should somebody, if they feel like these things are happening to them, call you?
I'm happy to talk to people who are currently employed with their employer and are facing concerns or have questions or problems at work. And obviously, sometimes you don't know there's a problem until you're fired, and then ultimately you need to talk to an attorney then. But at any stage that you have any issues at work, I am happy to talk with people, give advice, and kind of guide employees through situations. For example, a lot of times I wish people had talked to me sooner, because I probably could have helped them navigate how to handle a workplace situation, and hopefully prevent there being any escalation or problems that may have occurred down the road or would occur down the road.
Okay. All right, let's jump to the CARES Act signed by President Trump in mid-March, I believe, late March. And that extended some protections to employees surrounding this. Give me the scoop on that.
Sure. Under the CARES Act, there are actually several laws that were designed to help benefit employees and protect them because of COVID-19. One law that I want to talk about specifically is the Families First Coronavirus CARES Act, Response Act. And that law extends and affords employees additional protections under the Family and Medical Leave Act. Now, the Family Medical Leave Act has been in place before COVID-19, and that's the law that applies to employers that have 50 or more employees, and it gives protection to employees who have worked for that company for at least 1,250 hours a year, which is the equivalent of 1 year of full-time work. It provides 12 weeks of unpaid leave for employees who have serious health conditions, either personally or they need to care for a family member who has a serious health condition. And so what the CARES Act did is, in enacting the Families First Coronavirus Response Act, it actually provides paid leave to employees that are dealing with COVID-related issues, health issues. And it's at 2/3 of your pay, but compared to not getting, paid at all for those 12 weeks, that is certainly significant. And this new law provides protections to employees that are either quarantined and need to stay at home because they believe they may have been exposed to COVID-19, or obviously if they actually have COVID-19 and need to stay self-quarantined for 14 days or more. If they have a family member that has COVID-19 or needs to be quarantined, they would have these protections. And then the last area that's very important is, obviously a lot of working moms and dads out there have kids that are out of school now because of the virus and the pandemic, and they need to stay at home, or somebody needs to stay at home to care for those children because school's out, or their daycare provider or a child care center may be closed due to the pandemic. And so this new law that was passed at the end of March, actually gives up to 12 weeks of paid leave for those employees that are facing those COVID-related situations, which is really great. It's a great protection.
Okay, so 2/3, the paid leave is 2/3 of what they would normally make.
Correct.
And is this something that a company would, say mom calls in and says, not even anybody in my house has COVID, but we're all home because it's a stay-at-home order. My kids are out of school. I would like to have my, Family First Response Act time managed here, or, given here. Is that what would happen? Is that how it would be the employee that is asserting that right? Correct.
Correct, Amy. Under the Family Medical Leave Act, it is on the employee. The requirement is the employee needs to make that ask of their employer, and then the employer then has obligations to respond. So, with respect to this extended Family Medical Leave Act provision, the same recommendation would be in place, that the employee needs to reach out to their employer and let them know they need to take advantage of this new law.
Okay, so say mom goes to employer and says, hey, my kids are home. I've got, whatever her situation, 3 kids under the age of 8. I have to stay home. There's no daycare. Do I want to, get what's coming to me through the FMLA and the Families First, and the employee says, oh, we're not going to do that. What could she do right then and there?
Obviously, if she's made the request to the employer and the employer tells her no, first thing we need to make sure is there some reason the employer doesn't have to comply with this new law? Because there are some exceptions for different size employers as to whether or not they need to provide this leave, just like with the Family Medical Leave Act laws. But second of all, she can certainly pick up the phone and call my office and explain the situation, and I can help give her advice. I have already talked to several potential clients who have called because they have a situation that meets the criteria for this, and I've just advised them that they need to essentially educate their employer about the law. And obviously, if the employer is refusing, then they may need to hire an attorney to help with the situation.
And so it can just give us a really short and dirty, if somebody is going to ends up filing a lawsuit related out of one of these claims. Somebody has asked, they've been denied, and the employer, and then maybe the employer then fires the person for asking. I mean, that's a couple different things, but they come to you, you've hired them as a client. What are the 5 things that happen in a lawsuit? Like what happens?
Okay. So employment laws are different than most other types of areas of the law. If you're in a car accident, you can go file a lawsuit against the driver that hit your car. If you believe you've been the victim of medical malpractice by your doctor, you can go file a lawsuit against the doctor or the medical provider. Employment laws are different. You have to first go through an administrative process for to make a complaint of discrimination or retaliation against your employer before you can get permission to file a lawsuit. Now, that wouldn't apply to Family Medical Leave Act cases that I've been talking about. That requirement is not in place. But for your discrimination and your retaliation cases, you have to file what's called a charge of discrimination with the Equal Employment Opportunity Commission or your local state human rights commission. In Missouri, it's the Missouri Commission on Human Rights, and in Kansas, the state agency is the Kansas Human Rights Commission. And there are time deadlines associated with that. So if you feel like you've been discriminated against at work or retaliated against, it's important that you contact an attorney or contact the EEOC or one of these state commissions, because there are very short time deadlines for you to file your charge of discrimination. Specifically, you have 300 days to file with the EEOC, and then you have 180 days, or essentially 6 months, to file with your state commission on human rights, which would be the Missouri or Kansas Commission on Human Rights. And then your charge is then investigated by the EEOC or one of these state agencies, and then a determination is made whether they believe you have been discriminated against or retaliated against or not. And then you can get permission. It's called a notice of right to sue letter, but it's the letter that allows you to then proceed with your claim in court. And so all total employment claims from the date you file your charge of discrimination until you get to trial may take a year and a half. I think a lot of us are used to hearing about speedy trials, but that implies in criminal cases, civil trials take a lot longer sometimes. So, is your client paying you all along the way for the deal with the administrative hearings and then filing the lawsuit? And I'm sure there's depositions where you're interviewing some of the witnesses. What would your client's responsibility be in terms of money along the way? Yeah. So if you believe you've been discriminated against in the workplace or retaliated against, I offer free consultations. There's no charge for you to call my office and talk with us about your situation. Then if it's a case or situation I can help you with, then I handle cases like that on a contingency fee, which means I take a percentage of any money that you recover. if I don't recover any money on your behalf, then you owe me nothing back for the time or the money I've invested into your case. So really no downside for people to call and find out what their rights are.
Great, great. All right, so all right, now we're going to move on to the situation now where the stay-at-home orders are being lifted, people are being told to go back to work. In some cases, there are still people that have the option to work at home, but obviously there are situations where they need them to work, say in a factory or in a closed, tight office. What should the folks going back now to take care of themselves, and what rights do they have right now?
Yeah. Amy, that's a great question, because I think as the quarantining and the lockdown provisions are starting to be lifted and people are going back into the workforce in person, it's important for employees to know that they are entitled to have a workplace that's a safe workplace for them to work in. And you may have read in the news lately, there are some lawsuits that are starting to be filed because employees who are working during the COVID pandemic feel like their workplace conditions are not safe, that there's not social distancing occurring, that protective equipment is not being provided, that they're not allowed to take breaks to wash their hands, things like that. So if you're going back to work and you're feeling like it's an unsafe place for you, then you absolutely can talk to your employer about your concerns and to tell them what protective equipment or what you need to make the working condition or working environment at work safer for you. And obviously most people have heard of OSHA, and that's the Occupational Safety and Health Administration. Ultimately, OSHA has issued guidelines about COVID-19, and they're asking that you first try to work out the situation with your employer. But ultimately, if your employer is not complying or not protecting you, then you can call OSHA and make a complaint. And, with the idea that they would do an investigation or take action to correct the problem. If that doesn't work, then you certainly can contact my office and we can discuss the situation as well.
Are whistleblower claims part of the work that you do?
Yes. I represent employees.
That?
Yeah, absolutely. So it's illegal in the state of Missouri and Kansas to violate what we call like public policy rights. So things that would be protected would be things that would promote good public policy. So if you are trying to encourage your employer to not engage in conduct that would violate the law, that would be something that would be protected under our state and federal laws. And I represent employees who feel like, hey, I made a report that the company was engaging in illegal activity, and I believe that I was fired or retaliated against for making that report. The law also protects employees who have been asked to engage in illegal activity and have refused to do that. And so I represent those employees who have, quote, blown the whistle on their employer to say, hey, you're asking me to engage in illegal activity, or you're engaging in illegal activity and you shouldn't be. And I reported that to you.
Okay. Okay. Is there anything that I haven't asked that you feel like people should know in regards to just either specifically with this situation with COVID-19 or with employment discrimination in the workplace? Just I think something I didn't ask.
Sure. I think there's one area I would like to talk to everyone about, and that's as it relates to protections for COVID in terms of what, let me start over and say that. Normally, an employer is not allowed to pry into your personal medical health, your condition, to ask private personal health questions. There have been some relaxed restrictions about what employers can ask employees about their health because of COVID-19. So now employers are allowed to take your temperature at work to see if you're running a fever. And if you are, they can send you home. They are allowed to ask if you have been exposed to anyone who has COVID, or you've traveled, or meeting the criteria that would maybe mean that you had been exposed to COVID-19. So there are some relaxations of laws and questioning that can occur as it relates to somebody's medical health that is different than it used to be before the pandemic. So I think that's important for employees to know.
That is good information.
I think that can
Normally-
go too far though, Amy. I've heard of a situation where, there's, I was trying to, sometimes the employer can take that too far. So there may be limitations, but generally speaking, there's more leniency than there has been before in that area.
Yeah. Okay. Thank you so much for being with me this morning. I appreciate you getting up early. And what this will eventually end up on a YouTube page. It's going to live on my Facebook, Amy the Attorney page, and we'd love to share it with your pages. If you have employment related questions, just in general, but obviously we are talking COVID related today, I will put you the link to your website in the notes or in the comments section of both the Facebook post and the YouTube post so that people will know how to get a hold of you. I'm just really grateful because I feel like this is such an uncertain time right now, and being able to use the resources of very smart lawyers to come and talk to people about it is a great opportunity for me, and I'm glad I'm able to do it. So thank you.
Thank you. Thank you.
All right. Have a wonderful Wednesday.
All right. You too. Bye-bye.
Bye, Kristi. Thank you.
Thanks.